Presidential immunity has been a back burner topic for quite some time. It only tends to come to a boil when somebody attempts legal action against a president, which frequently. This certainly has its roots in common law, but likely the idea of presidential immunity predates that in the minds of the drafters of the Constitution. Ancient Athens held that public officials were immune from all forms of judicial review, as their government was a mix of elected and appointed officials who served specific terms. The Athenians recognized the idea that their government officials had been delegated power by the people. One of the goals of the people was that they wanted their government to be able to act decisively. Immunity to arrest and prosecution was deemed a method of facilitating this. Interestingly, Athenian democracy called for the immediate convening of a tribunal at the end of a government official's term. They would then be investigated, indicted, and processed legally if need be. I found that feature to be very interesting and considered it from time to time as a possible improvement to our government's operation. However, I think Americans lack the seriousness and the grasp of long term ramifications for such a system to work. Likely, it fails, at least this concept of tribunal review after a term. I think it fails beyond the city state level. It's not unlikely that it failed there as well, and that the great thinkers of the early republic were aware of anecdotes of such. Our ideas of immunity come directly out of common law. The English lacked any judicial remedy for a king, because initially the idea of a check against his power was beyond the theory of governance. As the government became more complex, with officials from the king's court moving around and essentially having delegated authority, the idea that some distant judge or government agent could perform criminal actions became a reality. The British government organically created the concepts of immunity for their officials, in some cases absolute and in others qualified. The idea was how to allow for the effective function of government while not having persons other than actual royalty be above the law. To do this, immunity, either absolute or qualified, became the default condition for government officials. Yet at the same time, forms of due process were created for stripping officials of their immunity. Now, I've run into a massive roadblock attempting to create the background information and supporting arguments uh, for the whole idea of present situation with presidential immunity. Before 2016, the articles on presidential immunity are rather subdued and have only narrow references to Presidents Andrew Johnson and Richard Nixon. A little bit of Clinton thrown in there. In 2016, there was a sudden explosion of articles and opinions explaining a multitude of politicized opinions on what presidential immunity should be. In short, the commentary on the subject is contaminated. Interestingly, as a source of sudden interest in presidential immunity comes from academia and legacy media. This gives us insight into the machinations of the establishment. This surge occurred well before Trump began making immunity claims. So I'll give you a quick sample from a quote scholar with expertise in legal history and criminal law. I know, easy for me to say. So, in his article, he talks about Hamilton, quoting him as such, saying, "A president once removed from office would be liable to prosecution and punishment in an ordinary court of law." He then quotes Tench Cox. Pardon me if I'm mispronouncing it, because this is like the first time I've ever said it aloud, but I've read it for years. His first name is spelled Tench. His last name Coxe. So, quoting Tench Cox, quote, "It is not so much protected as that of a member of the House of Representatives, or he may be proceeded against like any other man in the ordinary course of law." Based on those two statements, our scholar then deduces, quote, "I believe the punishment our nation's founders envisioned for government leaders removed from office would also apply to those who left office in other ways." So basically, you got Hamilton saying that once a president was removed due to impeachment, then the legal processes could be unleashed against him. Uh, and Tench basically says he thinks the president is open for uh, being litigated against all the time, more or less. And the conclusion is that as soon as the president's out of office, he can be litigated against. I don't see how we come to that conclusion. So Tench Cox is at best a second tier historical character. He's a great guy. I mean, he did a lot of stuff for the revolution in the early government, and his contributions are very noteworthy. However, virtually everything he did, he was kind of the second banana. In fact, he worked for the Treasury Department under Hamilton. Most of his work was in the arena of economics. However, in terms of understanding the intents of the Constitution, essentially the scholar is telling us if Cox conflicts with Hamilton, well, then the scholar thinks Cox's view somehow wins out. Considering what a heavyweight Hamilton is in terms of interpreting the Constitution through the various Federalist paper articles that appeared in newspapers, Hamilton's got to win out regardless of how you feel about him. Or at least he has to have a lot more weight placed upon his opinion. So let's restate Cox's quote. He says he, referring to the president, may be proceeded against like any other man in the ordinary course of law. Now, the phrase "in the ordinary course of law" has specific legal meaning and is not just an odd parsing of English. It means that which is the norm of day-to-day operations of how the law works. So, for example, if Trump got a speeding ticket, he would have to go through the same procedure everybody else did. He'd have to pay the ticket or show up at court and plea for a non-moving violation if he was trying to save points. If he committed shoplifting, perhaps, that'd be an interesting AI picture to draw up. But let's say he got caught shoplifting. He would probably have to go through the same procedures anybody else would. However, I would say most of what's been going on lately is not the ordinary course of law. Prosecutors running with the sole purpose of indicting, or excuse me, indicting a former president is not the normal course of law. Delaying indictments to coincide with an election year is not the normal course of law. Using laws in novel ways does not in any way conform to the ordinary course of law. Ultimately, we have a system that deliberately protects members of Congress from being arrested or while en route to DC or for anything they say on the floor of Congress. This is in response to past shenanigans that happened to parliamentarians in Britain and colonial America. The practice of using law enforcement to derail key speakers or critical voters on issues with a razor-thin margin had occurred in the past. Thus, protections were set up for Congress. In contrast, presidential immunity slowly built up over time as various litigants attempted to use the courts to hamstring various presidents. The idea of immunity most likely comes from Hamilton and is built up by the various precedents. Each judicial ruling that built on immunity tends to be narrow in scope, only dealing with the specific set of circumstances faced by the president at the time. It is my sincere wish that the Supreme Court greatly expands presidential immunity following the foundation laid by Hamilton. If this, all that was going on right now, was purely an issue of justice, these indictments could have easily been placed 1 to 4 years ago. The fact that there is a great wringing of hands over the idea of the problems of these court cases, will they or will they not occur before the election, is pretty much strong proof that the timing of this judicial action is in fact political and not justice. Even if the charges are fully justified, waiting to unleash them at peak political convenience is truly the hallmark of a temper tantrum on the part of the establishment. I don't enjoy this spectacle at all. It's tawdry and banal. It has nothing to do with it happening to Trump. I don't want to see political proceedings against Biden, Harris, RFK Jr., or anybody else who runs for or who may run for president in the future. Surely there's going to be a cadre of people who say, well, this is okay because this is only going to happen to Trump. It won't be used against anybody else. At the very least, that's a naive belief that this genie can somehow be shoved back into the bottle without immunity being expanded in Trump's case. However, there's a much worse interpretation. If the establishment is that all powerful that it can turn judicial warfare on and off at will, protecting those that it deems worthy and unleashing legal hellfire upon those that don't, you may want to live in that world, but I sure don't. So, in the comments below, what do you think's going to happen with the immunity case? It seems likely that we're going to hear something about it probably as this video drops tomorrow. What do you think about the ideas of the founders in terms of the president and immunity? Because they only made very uh, limited comments about it in the Constitution. They're pretty vague. But yet you have Hamilton very clearly spelling out what he believes the intent is. And of course, the court system has been appears to be slowly building on Hamilton's ideas. So interested in hearing what your opinion is. And of course, if you're commenting after the Supreme Court opinion has dropped, let's tell me what you think of their prescription for the problem. Please smash the like button. If the YouTube algorithm has brought you here and you're not a regular subscriber, please check out my other titles. I think you'll see a lot of different things that I'm into that you might be interested in. Please subscribe. And if you know someone who might find this interesting, please share it with them. Thank you for spending time with me this evening. Hope to see you again in a future video.